have several cases that are going to be argued today. I'll read out the cases, and if the attorneys would please state their names and their readiness to proceed. The first case is State versus Craig. Okay. The second case is State versus Saunders. All right. We then have two cases that have been consolidated for argument and decision. We have Zuriak versus Durrani and Hamilton versus Durrani. All right. And then the second two cases that have been consolidated are Wiseman versus Durrani and Jones versus Durrani. Okay. And Mr. Statman. All right, so everyone's here. We're going to start with the Craig case. Mr. Trapp, would you like to reserve rebuttal time?
Yes, thank you. Good morning, Judge Krause.
How much time would
I'd
you
like to reserve 3 minutes for rebuttal, please.
Okay.
May it please the court. Good morning, everyone. We have a case in which Ms. Craig is driving her automobile and is stopped by the police, and she has a concealed firearm in her purse around her person in the driver's seat.
So first question, how do we know it's in her purse?
It's in the motion. That's where I got it from.
In the motion to suppress?
It's in one of these motions that they admitted that she had a gun in her purse. I didn't make it up. It's what I read it somewhere in the motion.
But it's not specified anywhere in the indictment or bill of particulars about
No.
where the gun is located?
I don't believe it is.
Okay.
So a gun, a firearm, particularly a handgun, is always concealed when it's in the interior of an automobile. And that is a result of the concealed and ready at hand requirements of the concealed carry statute. Because, and the state doesn't really question this point in their brief, but I want to make it, it's the first point I've got to go through, is the gun is always concealed because it's not visible to a casual observer from the outside of an automobile. And that's the test. So there's really no practical way to have a firearm inside the interior of an automobile without it being concealed. If it's on the seat next to you, it's not visible. If even it's on the dashboard, it's not visible. There's going to be some obstruction concealing it, and even a partially visible but partially concealed gun is considered concealed. So the law here under Ohio is you're stuck if you have a gun inside a car. It's almost always concealed. I can't imagine.
What she was convicted of, though, was the concealed carry,
Yes.
not the transportation in a motor vehicle. That was
Right. The
that was
improper
marked.
handling was
Okay.
dismissed as part of a plea. So I didn't, because I can't appeal that. I did notice that it's pretty much the same standard because the improper handling makes you're not allowed to have the gun available for self-defense. That's kind of in the statute. It has to be out of your reach. And so it's somewhat the same argument that's not raised here because this is just an appeal of a CCW conviction.
Okay.
So the reason that Ms. Craig was not a qualified adult, legally able to have a concealed firearm, is because she was convicted twice when she was 16 and 17 of misdemeanor resisting arrest. And it looks like she was convicted when she was 17 of I'm sorry. Conviction's not the right term. She was adjudicated delinquent for misdemeanor resisting arrest, and she was adjudicated delinquent for attempted receiving stolen property. And on that basis, 29.3.101 classifies her as not, she doesn't meet the requirements of a qualified adult. So we're here today to answer the question, is this consistent with the Second Amendment? And I know that this is the exact same panel that issued the Hall decision. And I'm happy here today, I'm not attacking the Hall decision. I'm telling you the Hall decision supports my claim for Ms. Craig here that the Second Amendment protects her conduct. Because we have two decisions from the court, the Barber decision and then the Hall decision, and they're in opposite. And, but I'm not attacking Hall today because Hall says you can ban concealed carry. It's a little different than the Barber. It doesn't literally look at the why. The why was to prevent attacks from concealed firearms. So it's different, but Hall decision said you can ban concealed if you allow open carry. And Desmond Hall was on foot, so he had the opportunity of open carry. Ms. Craig doesn't have that opportunity here.
So that's from your conclusion that you can never open carry in a vehicle?
It's my understanding of the law, which I cited in my brief, that a gun is almost always concealed in the interior of a vehicle.
You just said almost.
I think it.
I mean, is there a way to open
She was
carry?
holding it upstairs where in her hand inside the car, maybe by the windshield. Maybe she had a car with a big windshield. It
What
might
about
not
on the
be concealed.
dashboard?
I think that's concealed
How?
because it's not visible to a casual observer outside the vehicle. That's the test.
What about a gun rack?
A gun rack is not what we have here.
Well, obviously,
A
but like a
gun-
gun rack would be pretty open to an observer in the back of a car that could still be reached.
We're not talking about a pickup truck with a shotgun in the back, as you might see in very rural areas of this country. A gun rack is not concealed in a pickup truck, that kind of thing. We're talking about a handgun here in the interior of a vehicle, and that is almost always concealed
Almost
by the
always.
operation of the law. Well, there may be, it's a factual determination,
Well, this is an as-applied challenge, and we have a gun in her purse, right?
yes. So she can't do that according to Ohio's law, which because she was adjudicated delinquent at 16 and 17, she can't do that.
But you want us to conclude that there's no way for her to be able to carry a gun in a car unless it's concealed.
The Taurus firearm that she had with her is going to be concealed, no matter where it is in the interior of the vehicle. Yes.
Right, we would have to make that conclusion.
Yes.
That there is absolutely no way to carry a firearm in a motor vehicle unless it's concealed.
Inside, right.
Right.
Right. Yes, you would have to do that. And that's, in my brief, I cited those cases. Embry, I think, is one of them.
Does she have a choice? Does she have to choose, or can she choose between getting in a car or carrying openly?
I'm not sure what your question is getting to.
If she wants to carry openly, can't she walk?
Yes, she can walk.
And she can engage in her constitutionally protected right to carry a firearm, but not getting in a car.
She would be protected from the reach of the state if she did that. She would also have to forfeit, it's being a mobile society, she would have to forfeit ever getting in a car with her handgun.
Which is not a constitutional right, at least to getting in the car part. Is that right?
That's not a constitutional right, but it's a significant amount of time that individuals spend in their car. I think it's an hour a day. I put that in the brief. People spend driving their car.
Well, she has that choice. She could not carry the gun in the car and enjoy the benefits of driving around in a car, or she could carry openly outside of the car.
She has a choice, but she's got a Second Amendment right to bear arms. In that, nowhere does it say you can't bear arms while driving a vehicle, or driving a coach, or riding a horse. Nowhere is that in the Second. The question is, does her having a car, having a gun in the interior of a vehicle where Ohio considers it concealed, does that violate the Second Amendment?
Would she be allowed to have it on a bus?
Well, it'd be concealed on her person then. I've never had a person charged with carrying a firearm on a bus, so I'd have to think about that a little more. It depends on whether a casual observer would notice that you had the firearm. from the outside of the vehicle. So, yeah, it's important you find that this law operates the way I say it does here, but it does. If you look at the case law, you'll find that it does. A gun inside a car is almost always concealed. So,
You just keep saying almost.
well, it's a factual determination.
Right. So there is a way to carry a gun in a car,
I
not
don't know.
concealed.
I wouldn't be advising any of my clients, let's go to a jury trial and see what they say. Hopefully they find it's almost concealed, you know. That would be a very hard thing to do, so. The Hall decision, as I said, supports my position here, because Hall says you can ban concealed carry without, as long as you leave open carry available as a defense. She doesn't have a way to open carry inside the interior of an automobile. And so we're back to the Bruin test here. The why matters. And the state didn't put on any evidence that that would be a historical analog here. They didn't say you're in a coach in the driver, a historical law where a driver of a coach was banned from having his pistol hidden on the floorboards or hidden inside the coach. So they didn't come up with anything like that. We also have the fact that the reasons here are adjudications, which is court and Thacker said are not relevantly similar to adult convictions. So,
Thacker was concerning complete and total disarmament. Right?
yes.
Indefinite.
So Hall here says they can ban concealed carry, and it really doesn't matter why they do, because historically they could ban it for the reasons of avoiding surprise attacks.
I think Hall was saying the why is similar now to what it was when they were doing it back in the day, right? It's the same why.
I don't think it's the same why, because Ohio's law has changed now so that the general population can carry concealed weapons if you're a
So
qualified.
you don't think the legislature is concerned about certain people carrying concealed and engaging in sneak attacks like they did back in the day?
I'm not sure I can second guess the mind of the legislature, but I would point out that these laws were written before the Second Amendment was incorporated against the states in 2010. And in fact, that's why we're here today, because in 1833, the Supreme Court said you don't have to pay attention to the first 10 amendments because they only bind the federal governments, and it's Barron versus City of Baltimore. So all this case law from 1833 on, the states doing this wouldn't have to worry about whether it offended the Second Amendment, because they were told by the U.S. Supreme Court only binds the federal government. So we've had a long period of time where the Second Amendment has been torn and bleeding at the courthouse floor. While other amendments were incorporated, it was left unincorporated. And that's
But you think the why is different now for banning concealed carry than it used to be? Is that what you're saying?
the why here is she was adjudicated of resisting arrest at 16 and 17 years old. She was adjudicated of attempted receiving stolen property. That's a different why. That's what they're using to justify their depriving her Second Amendment rights.
Under the logic of Hall, couldn't the state legislature bar all concealed carry?
Yes, under the logic of Hall, if it's not protected by the Second Amendment, then the state legislature is free to do all that. They haven't done that. But where there has been a sea change in Ohio law and laws around the country to allow concealed carry.
So you are at your time if you want to reserve your rebuttal.
Yeah, thank you, I will.
Thank you. May it please the court, opposing counsel. Before I begin, if there are any initial questions from the court, not seeing any. Judge Nestor, you asked about where the gun in the purse comes from. Just from a quick review of the documents that I had, I didn't see it in the motion to suppress. It is referenced in in the motion to dismiss. I don't see it in there. It does appear in an amended motion to suppress. I didn't see it in the original motion to suppress, but in the amended motion to suppress, there is a factual assertion that the firearm was in the purse. If it appears anywhere else in the record, I
But
will-
it's not an adjudicated fact in any way. It's just a
No.
representation of a party.
Correct. I think the representation of the parties may be something that's important here when we're talking about a distinction between a facial challenge and an as-applied challenge. At least for the purposes of a facial challenge, it's incumbent upon the moving party to establish that there are no set of circumstances in which the application of the law would be constitutional. And I think that's why you're hearing from opposing counsel that, under any set of circumstances, the gun is always going to be concealed. Therefore, she has no right to open carry as it relates to being in a vehicle. I just don't think that's true. I think there's any number of circumstances I can consider in which a firearm would be visible to to a person who was able to ascertain see the person in the vehicle. And I think, in fact, the improper handling statute makes specific reference to circumstances in which a firearm can be displayed openly. Specifically, I can't remember who mentioned it, but a gun rack would be one of those circumstances in which the firearm is prominently displayed to the average reasonable observer who would be able to observe that. I mean, obviously.
What about counsel's distinction of a pickup truck in rural America versus whatever the vehicle was here in urban America? Like, it seems unlikely you're going to put a gun rack in your Civic.
I mean, obviously the term gun rack, I think, brings to mind like a specific type of way to possess a weapon. Like when I hear gun rack, I think of, I've got a 30-06 or something like that, like a long rifle on a honest to God rack. But there's no reason to think that term, as anticipated by the legislature, couldn't mean something like something that you place on the dashboard, and I'm aware that those exist for like a handgun, for example. Like a container or something that openly displays and contains that.
Is that marketed to the general public? Like, this is something to carry your handgun?
I believe so. I mean, this is only from personal knowledge. It's not on the record, but I believe there are, whether they're marketed as gun racks, there are, I guess you would call them equipment that you can use to attach to your vehicle, whether that's, I know some also exist that attach to like a cup holder or a console that can be used to display the weapon and keep it accessible should the need arise for like self-defense.
Is open carry defined in the law as being able to actually see? Is there any definition that is applicable to what is open carry that we could apply to the vehicle?
I'm not sure. I haven't briefed that issue. I don't believe that the term open carry is specifically defined. I think the way that Ohio's firearm regulatory scheme separates it and distinguishes it is between carrying a firearm concealed and not. So, for example, for improper handling, there's a definition for unloaded, but there's not a definition for loaded. And so the byproduct of that is anything that is not unloaded is loaded. I think the opposite would be, the same would kind of be true here. If the firearm is not concealed, you're carrying it openly, if that makes sense.
I'm just wondering if you could post a notice on your window.
I'm sure you could, but I don't know that the definition of concealed would necessarily apply to notice. Like if I'm wearing a t-shirt, for example, that says I'm concealed carrying, I don't know, or I'm open carrying, for example, I don't think that changes the factual determination that the firearm needs to be readily observable by a reasonable person. I know that's...
But it might help, though.
It would. Yeah, I mean, certainly it would be a fact to consider, which I think takes us to the as-applied challenge, which it's incumbent upon the person in this case to indicate that their rights are being violated in a particular way to the facts. We're not dealing with a situation in which I think even as the facts are proposed, where the defendant in this case was open carrying. I mean, she had her firearm, if it bears out that way in the record, concealed in her purse. And so this is a situation that's directly considered, both as we see it, both historically as determined by the court in this panel in Hall, and would align with the historic need to regulate and protect society against those sort of concealed firearms.
So this is just a situation where the legislature has carved out what it believes to be certain categories of people that it believes to be too dangerous to carry concealed.
That's the way that we see it, and I think a straightforward application of Hall would be applicable here. This is the same type of scenario that was considered by a different panel in Barber, and although this panel declined to, I guess, directly overrule Barber or directly speak to that effect, it hasn't, as far as I understand, this court hasn't the opportunity to discuss this one specific subset of disqualifying factors. But as this court stated in Hall, this is more akin to an equal protection problem about there is, as this court has recognized, a history of regulating concealed carry that comports with not just the state but with this nation's history and tradition, and therefore it meets the test that it's required to under Bruin. Now, whether or not the defendant has some sort of due process claim, as in I'm being unfairly discriminated against due to my status as someone who's been adjudicated, that would be a question. Because history supports it, Bruin tells us that the Second Amendment isn't what protects you there. It's the 14th Amendment, for example. Because I've brought up Barber, I did want to draw a distinction addressing some of the concerns in that case, which I think are particularly applicable here. Although I think a straightforward application of the Hall decision is relevant and is sufficient to overcome the challenge in this case, I did want to address some of the concerns espoused by that different panel in Barber. One of the current concerns they had, specifically as it relates to juvenile adjudications, is they believed that the nature of juvenile adjudications are such that the determination of dangerousness, to use their word, is something that should be that should end as a matter of course. That it is presumptively impermanent and should automatically end rather than being subject to some sort of relief that's provided by the state, and something that lasts indefinitely without any further action of the juvenile who was adjudicated delinquent. What I will say in this case, the way that the scheme, Ohio's scheme works for those who have been adjudicated or convicted of resisting arrest is something that ends automatically. So resisting arrest is a crime. It's one of several that's included in Ohio's CCW regulation scheme that ends after a certain amount of period of time.
Just for the CCW piece. For somebody adjudicated juvenile who, them not allowed to carry concealed ends, right? Automatically, is what you're saying.
Just for the resisting arrest adjudication.
Okay.
And that's just for juveniles?
No, that's for adults as well.
Okay, and that's somewhere in the CCW law?
So,
Is that the 10-year limitation that's in the state's brief?
correct. So 2923.125, it's 2923.125D. I'd have to look back through my notes to figure out which of that.
But it's not dependent on the juvenile status, though. It's dependent on the nature of the underlying charge.
Correct.
Because it seems like, well, what was the underlying charge in Barber versus this, where they're clearly not serious juvenile adjudication?
I mean, I might disagree with you about the seriousness level of them, but I will at least concede that they're not, for example, like a violent adjudication or something like that. But I guess my point is, at least when we're doing sort of an overarching historical analysis and where we're not tied to a historical twin, I think what's good for the goose is good for the gander here. In other words, where the concern that Barber court had about the time limitation, that determination of dangerousness not being impermanent, it is impermanent with relations to adjudications or convictions as it relates to, for example, resisting arrest. I think a certain number of...
That one completely solved it for this defendant because it was not just resisting arrest.
Well, I mean, to the extent that, when you say solve it, I mean to the extent that...
It wouldn't go away. The other adjudication wouldn't go away.
Correct. But because we're in an as-applied challenge, we're still within that 10-year period. So even if this court were to even if this court were to solely rely on Barber, for example, and find that I think it's a attempted resisting stolen property felony adjudication was improper, I believe, and it's the state's position, that resisting arrest adjudication would still be sufficient under Barber because it is impermanent. It's going to end 10 years after. Now, we're within that 10-year window, so it's just an additional as-applied fact to consider. But the same would be true for there, and I believe, like, for example, having multiple negligent, I think it's assaults or negligent assaults. There's, I don't remember the exact categories as I stand here today, but there's one 3-year, one 5-year, and then resisting arrest is a 10-year limitation that
You're
ends
not
on.
for certain convictions, you're not forever adjudicated, or not forever prohibited
Yeah,
from concealed carry.
when we consider, if we were to consider, which is kind of how the Barber Court framed it as, you know, treating these convictions, these adjudications as a stand-in for a court or a legislature determining that someone is dangerous. I think, as I understand the decisions out of this court, both in Thacker and in Barber, there has to be some sort of, at least for juvenile adjudications, we know this for certain. I don't know if the court has had the opportunity to address it otherwise, but at least for juvenile adjudications, there has been a suggestion by this court that that dangerous determination should be impermanent, at least for
So
juvenile
Ohio is an
adjudication.
outlier in that regard. I mean, most states do have an end to juveniles being prohibited, or people with the juvenile adjudications being prohibited from having firearms. There's
For
usually-
like a certain amount of time.
Yeah, there's usually a end date.
That's my understanding. That's
Yeah.
correct.
Could the defendant in this case have expunged these
I believe
at
so.
the age of majority? Or
Yes.
at the, after juvenile, whatever the penalty?
I believe once the disposition is over, which normally is at the age of 21, I'd have to look back to, I don't know, it's not in the record in this case when those end, when that ended, but the jurisdiction of the juvenile court for the purposes of dispositions would end at 21. So once they're 21, it's my understanding that the expungement law would allow them to expunge it. That would serve as, at least as I understand the law, a relief from firearm disability or CCW disqualification. Once those convictions or adjudications are expunged or sealed. There's case law out of, I believe, the second district that says that explicitly. I don't know that this court, for example, has had the opportunity to rule on it. I also know that right now, there's a House Bill 5 in front of the 136th General Assembly that aims to kind of clarify some of the language about relief from firearm disability and CCW disqualifications to kind of make that more clear. But that law is obviously not applicable here. I believe that I have hit on everything I needed to, so unless there's any further questions from the panel. All right, thank you very much.
I want to be very clear that this is not a facial challenge. This is an as-applied challenge by Ms. Craig, who is an adult now, but was adjudicated delinquent at 16 and 17 for misdemeanor offenses of resisting arrest and attempted receiving stolen property.
And
And
the-
has a
the-
gun inside a car, which she is driving.
The theoretic purpose of her having the gun is self-defense.
Yes.
And if she wanted to, it sounds like she could have had her record expunged and she could have then engaged in the behavior.
I don't know about that, and I don't believe that's in the brief that the state filed either. I just don't know. I think that's outside the record of the case, is saying what she could have done at this point. She got arrested and indicted and charged with conduct that is protected by the Second Amendment. That's why we're here. Mrs. Craig is not dangerous. She's not dangerous because she was resisting arrest as a juvenile. She's not dangerous because she got an attempted receiving stolen property. She didn't present any physical threat of harm to another the way that was approved in the Rahimi case.
But a juvenile is not inherently dangerous just because they're a juvenile.
No, and they shouldn't be arguing that she's dangerous here, and that
But the CCW law prohibits juveniles from having.
that's a capacity argument. Yeah, not because
Right.
she's dangerous as a juvenile, it's a capacity argument.
But it's kind of the same thing, right?
I don't think so. But you don't have the capacity to do a lot of things as a juvenile that you do as an adult.
And the lack of capacity results in dangerousness, right?
No. Lack of capacity doesn't result in dangerous.
What are they
Ju-
incapable of?
The
What are the juveniles incapable of?
contracting, having a.
No,
bonding
in terms of the
contract.
gun. You said that it's a lack of capacity with respect to juvenile.
Yeah, they don't have the right to purchase a firearm because they're a juvenile. Once they reach the age of majority,
Because
they
it's,
have all those civil rights.
because it's determined as a juvenile, they don't have the capacity to safely possess a firearm. Is that-
I'm not sure about that. Juveniles here had to, when the militia, they had to go show up with rifles and weapons ready to serve. Long history of juveniles handling guns in this country. Barber he was adjudicated delinquent for a concealed carry charge. I'm out of time. Thank you very much.
Thank you. Thank you both for your arguments this morning. The case is now submitted. All right, the next case is State versus Saunders. Morning.
Your Honor,
Would you like to reserve some rebuttal time?
I'll take 5 minutes if you allow.
Of course, you can add as much as you want.
You good, Joe?
We're ready to go.
May it please, Your Honor. Rudell Sanders was a resident doctor conducting practice ultrasounds to possibly help him get more proficient at them. He was never compensated. He was properly licensed, and he was not practicing medical performing examinations.
He was not what?
He was not conducting examinations. He was not conducting a medical procedure when doing those training exercises in his own home.
Oh, and what was it?
It was using a butterfly ultrasound device to improve his proficiency in doing ultrasound examinations.
That somehow doesn't qualify as a medical procedure?
Correct, because it's got to be for diagnostic purposes. So going back and practicing it and telling somebody you're just trying to get better at doing it is no different than when I was an electrician apprentice and I would go home and have to learn how, and practice how to bend pipe and wire things. I wasn't allowed to do that on site yet, but I was required to go back home
Is
and
there any
practice to get more
requirement?
proficient.
Is there any requirement for a resident to do this off of a medical site?
Well, there's no requirement. Well, yes, there is, because you can't practice on site. There's no setup to do it. So this was not a requirement for the residency program. He had a conversation with Dr. Hellman, who was an instructor on ultrasounds, and talked to Dr. Hellman about the idea of practicing to get better at it. And Dr. Hellman said that he encouraged him to continue to try and practice. You can't just go around into hospital rooms and walk in and say, I'm going to practice on you today if you don't mind it. There's somewhere you're going to have to do it. There's a difference between the residency program itself that he was in and what he was attempting to do outside of that cardiac residency at the time, which was to get better at doing ultrasounds.
Can we back, so the prohibition is against practicing medicine without the appropriate license or certificate.
Correct.
So what did his license or certificate allow him to do?
It allows him on site to practice medicine under the supervision of a doctor, but it requires you to be practicing medicine. It means doing exams and procedures.
Okay. And so your argument is that because what he was doing at his apartment was not the practice of medicine?
Correct.
Okay.
And it was very, very clear to each of the people that testified that that was the case. They both said over and over and over again, what I knew I was doing with him was allowing him to practice and get better at what he was doing. I was trying to help him. Some thought he needed 100. There was disputes about whether or not that, but each one didn't say I was looking for a diagnosis and he was going to do one for free in my house and I was going to learn
Well,
about
that's
all
where I
the...
got confused. I thought that they were looking for some sort of diagnosis.
What he had told each of them was, I think is in discussing, was the fact that you are a runner, you should be getting things like this done. But what he didn't say was, I'm diagnosing you. All he did was walk them through. They had their cell phones. They could see everything he was doing with the device. It was a Bluetooth connected device that allowed them to see on the screen exactly what areas of the body were being covered when he was doing heart, the arms, internal organs, down to the legs, genitalia, and everything.
But
You
part of
walk-
this practicing with the ultrasound involves interpreting what the ultrasound is showing.
Absolutely, and he never did that. And they never got a write-up, and they never got a diagnosis or anything else at all like that.
So you're saying he ignored any signs and symptoms of problems while he was practicing with these ultrasounds?
What I'm saying is, none of that was ever communicated one way or the other. So whether he saw something or whether he didn't see something is not in the record. What is in the record is that he walked them through, described what he was doing, and they could watch all of it. So I'm assuming if at some point something was seen or whatever, like what is that big blob next to my heart or what is that spot, it would have been discussed. But neither one of the two alleged victims said anything like that occurred.
But
they-
when he's performing the ultrasound, and practicing as you describe it, he's looking for those things because that's part of the
I don't know if
practice.
that's necessarily what he's looking for, because it was never described by anybody in terms of what that was. All that was described was that he was doing it. To infer exactly what else was going on, all he said to each of these folks, when they agreed, what they were doing with him is helping him by doing more ultrasounds.
So you're saying that the record doesn't show that that he represented to these people that it would be beneficial for them to get an ultrasound to check on their health, their cardiac health,
No,
history of-
I think absolutely he told them about the fact that doing ultrasounds is always beneficial to them. But he
But
also
doing
said,
these, going to his apartment to do these ultrasounds would be beneficial to them. So he represented to them that there was going to be some sort of diagnosis involved. But then what you're saying is once it actually happened, there was no diagnosis.
no, I'm saying if something occurred, I think the next logical step is you have to come to the hospital and go see a professional, because I can't do that.
And by him not giving that information, he's telling them that there was no problem seen in his ultrasound exam.
There's an inference, I guess, there, but I don't know if that's the case. I don't know if that's the case. But what Dr. Hellman also testified to is this would not be unusual for someone to be doing it outside of the school setting.
Did he identify that other residents were doing this outside of the school setting?
Did who?
Dr. Hellman.
It was never asked.
Okay. Did Dr. Hellman say that it was acceptable for him to do it outside of the?
So what Dr. Hellman said was this, which was, he said there is a big difference between educational and diagnostic. So he recognized the fact that there are opportunities to do ultrasounds for educational purposes only, as opposed to diagnostic. And then he talked about the fact that that was necessary. He said that the device was used for learning, and that's not clinical, the butterfly device. He said that he and Saunders talked about doing these, but the only reason that he would not review them is because the UC medical devices, the equipment, was not compatible with a butterfly. So it wasn't he told him not to do them, he just said, I can't review your scans that you're doing outside of this practice because the UC equipment doesn't work with the butterfly that you're using. He also said that other doctors use the butterfly device on practice. There was no hospital policy on using the ultrasound devices outside the clinical setting. There was afterwards, but at the time there was not. He also said he told the medical board that Saunders' actions were reasonable. He said the ultrasounds might help in pursuing this area in terms of practicing outside of the hospital setting. So that's what Dr. Hellman said. He said he told the medical board that what his actions were about doing these outside were absolutely reasonable, and there's a difference between educational and practicing medicine and diagnostic.
That's what this comes down to.
I think that's absolutely,
Is
because
what-
he has a certificate.
Was this educational or was this
Absolutely.
practicing medicine?
Absolutely, I think so.
Yeah.
Because look, he had a certificate. The certificate, he's a resident doctor. To say he cannot call himself a doctor, resident doctor, first of all, he never called himself a doctor because both.
Wait, he's an MD, right?
Pardon me?
He's an MD.
Not yet, not yet.
Oh, he was not, he hadn't
Correct.
graduated from medical school yet.
Right. He's in his residency at this point, so he doesn't qualify yet at this point.
Okay.
So but he's
Well,
referred to as a
don't
resident
people-
doctor.
Don't residents call themselves doctor?
Absolutely. Absolutely.
Wait, residents are usually graduates of medical school.
Medical school. He's in his residency program. He's finished medical school.
Yeah,
Excuse
so
me.
he's,
I'm-
so he's an MD, and most
He's just
people.
not fully licensed at this point. So what he gets is he gets a certificate that renews every single year. And as long as you haven't committed a violation of law or some ethical issue,
But just-
you pay $130 and you get it for another year.
Just so I understand, so he graduated from medical school. He's an MD.
He's a first-year resident.
So he can use doctor, right? As an MD.
Right.
even if you don't have a license.
Correct, and the only question is about how you may or may not be able to use it if you're trying to perform some sort of
Well, no, it's
exam.
just how he's allowed to practice. He's not allowed to do medical
Procedures.
procedures outside of the clinical setting that
Correct.
he's doing his residency
Right.
in.
But in this case, there was at least an allegation and a finding by the trial court that he had somehow misrepresented who he was and what he was by a doctor. And the difference was is that each one of these alleged victims all both admitted that he referred himself as a resident doctor, doctor in training, and everything else. And the closest you got to, and it was one of the, I think, mistakes, in fact, found by the trial court in this case, was in terms of how CC, the alleged person was, he at one point said, I assumed he was a doctor. That was on page 46 of the transcripts. There was an objection, and the trial court said, well, I'll accept it for what it's worth. That's the closest you got to it, was his saying, I assume. But he admitted at other times, he said he knew he was in training to be a doctor, said he was a resident doctor, he was training to be a doctor. So it made it very, very clear in terms of who he was and what he was doing. So neither one of these people were led to believe that this was a doctor who had graduated through residency and was now fully licensed as a medical doctor in Ohio, now doing ultrasounds for diagnostic purposes in his home. They each knew exactly what was going on as they were helping him get more proficient. And through their friendship, doing exactly what Dr. Hellman said would be reasonable, who somebody who's trying to get more proficient at doing these.
Counsel, can I ask you about the issue of compensation?
Yes, sir.
Is that limited to monetary compensation, or can compensation come in other form,
I think it's got to be something clearly of identifiable value.
like experience?
I'm not necessarily sure experience, because I think that's a little bit different. I think now we're in the area of benefit. And that's basically what happened here, was this trial court tried to equate benefit with compensation. And I think that's inconsistent with, I think, all the law that we presented to you, whether you look at OEC or anything else at all like that. It just does. It requires, I think, something that has an identifiable value. When we talked about blood in one case, in terms of that being sold and it has a value, it can be traded and it's identifiable. The closest you get to this, the closest you get to trying to place some sort of identifiable value to what was going on was what Dr. Hellman said. It might possibly assist you, in his view, depending on the position you were going for. But it didn't get a certificate. What he was doing didn't give him another enhancement, certificate, or license that you would say would have absolutely value. It would be that he would be proficient possibly in using ultrasounds.
By practicing on these patients for free?
Well, it wasn't, but there was no, I mean, it just becomes more proficient. It's just a way to get better at what you're doing, and to say that that in and of itself has a monetary value or for compensation, I don't think that that's exactly what was intended. I think the fact that compensation was used explicitly, and basically you'd be, I think, breaking new ground in this area in terms of practicing law without a license, including compensation. If you were to say that somehow getting better at what you do is compensation, is a benefit that equals compensation. I think compensation equals something of value. If they wanted something more, they would have said more. They would have gone on to explain more things. But compensation, I think, allows you to say, maybe you traded, bartered with somebody to do something. That has value, because you could put a monetary value on the service that was traded or what was received in return. And I think that's it. I think it has to be something you can at least put a monetary value on, even though money wasn't exchanged.
You're
Looks
well
like
over your initial time if
That's-
you want to reserve rebuttal
I
time.
appreciate it. Thank you.
Thank you. May it please the court. Mr. Gallagher. If there's any immediate questions, I guess where I wanted to start with this distinction that opposing counsel, I believe, reads into the plain text of the statute for educational examinations. There's no delineation in the statute as it relates to this case that would define examination in a way that would, I guess, prevent application of this law for examinations that are educational or for a monetary value.
This is practicing medicine.
Right.
Okay. So what is the definition of practicing medicine then?
The ones that are relevant here, Your Honor, specifically relate to the use or the words of a letter doctor, use of any words or letters or any other title in connection with their name in a way that represents them as practicing medicine and surgery or examining or diagnosing for compensation of any kind. Those are the two circumstances, that definition.
Well, so it seems like we've established that he could probably call himself a doctor.
I would disagree with that, Your Honor, in the sense that, I mean, if I have a Juris Doctorate. If I put doctor in my Tinder profile, that would be, I don't think that would violate the law here. The issue comes specifically from, as stated in the statute, representing the person as engaged in the practice of medicine and surgery. And specifically as it relates to this case, having the appropriate certificate or license in order to do so. As has been mentioned already in this case, the defendant doesn't have a license to practice medicine. He only has a certificate which specifically limits him to what he can and can do as it relates to that certificate. I like to draw the distinction specifically between a license to practice medicine and a certificate. In regards to what you're saying, Judge Nestor, about, can he use the term doctor? The use of the term doctor or MD in order to represent yourself as someone who is engaged in the practice of medicine is something that is provided to you when you get your license. So the adverse...
So you're not allowed to use the doctor after you graduate from medical school before you get your license? You can't call yourself doctor?
Not if you're going to use it in a way that represents you as practicing or engaging in surgery and medicine. So
Okay.
if I were to go out and put, on an advertisement and say, Dr. Wessels, come in and get your examinations done or something like
Yeah,
that.
but that's what the argument here is. The argument is that this was not for the purposes of diagnosis. This was simply to get better at ultrasounds and educational experience.
It was absolutely to practice surgery and medicine in terms of the facts that were presented in this case. And if I can explain
Yeah,
why.
please do.
It could not be more clear that what he was providing these individuals in his mind was some amount of service. He was engaging in providing an examination through, and we know this from his own words and from the actions that were presented in court. You can look at the course of conduct that was shown at the trial and that he admitted he did to the state medical board. He would find specific individuals who were involved in his running club, approach them under the precept that running carries with it some sort of inherent risks in your heart, and wouldn't it be good for you to, a benefit to you, a medical benefit to you, to understand the risks associated by me conducting a medical examination of your heart in order to let you know about any particular risk factors.
But just so I understand the record, the people that he approached, these were people that he was friends with, right?
I mean, I can't speak to the
I mean, it's not
interpersonal-
like he just went up to some random person in his running group. Weren't these people that he became friends with, that he talked to about what he was doing?
So I don't want to misrepresent the use of the
I'm
term
just
friends. They had interpersonal relationships, certainly. They were all
Yeah.
part of the same running group, but I don't know if it would be, it's not like,
But you're saying that the record supports that he told them that he would do these ultrasounds to diagnose them.
correct. And I believe it's the testimony of the victims in this case that they would not have done it had they not been incentivized or based on the misrepresentations that he made.
They weren't doing it as a friend to help him
No,
out.
I believe they specifically testified that they were doing it because they wanted to get more information, which is part of the plan of incentivization that he presented to them. I am a doctor, not true. I have to do 100 of these as part of my certificate or training program, not true. And so why don't you come to my house, a place that I'm not allowed to perform these examinations, and I can perform those examinations on you, something that's not a part of my certificate and that I'm not allowed to do.
That third part, not, come to my house where I'm not allowed to perform it, where do you get that?
Specifically, and it was actually, it appears both in the statute as it relates to the training certificate, but it was also testified to by Dr. Lininger and Dr. Hellman, that with specific regards to his certificate, he's only allowed to perform any form of examination at both of these have to be true, at a clinical setting, i.e. in a hospital or at a doctor's office, and under supervision.
So that
there-
was based on the two doctors, one from UC and one from the medical board?
Correct. They both, the requirements that are contained in the certificate also appear in the Ohio Revised Code, those requirements, but they were reiterated at trial by those witnesses. And Dr. Lin,
Can a non-physician perform an ultrasound?
and not be in violation of this law? When you say non-physician, you're meaning someone who has neither a license or a certificate?
Right.
No.
Could a nurse do an ultrasound?
Specifically, as I understand the statute,
It seems to me that usually.
There'd have, when you say nurse, I presume based on that there's some manner of certificate that would be involved in that. But,
But this person bought this ultrasound equipment on their own, right?
right.
And theoretically, anybody could buy the ultrasound equipment, and they'd all be in violation of the statute if they were doing ultrasounds?
On other people, I would believe so. I mean, the specific the thrust of the law is to prevent people from either representing or engaging in the illicit practice of medicine if the state of Ohio hasn't deemed you to have done the specific training or the requirements necessary to obtain a license or a certificate. So while there may be no specific harm for me to go around and presumably, I'm still not allowed to conduct those examinations if I don't have the certificate or the procedure, which is, I think, presumed in the framing of your hypothetical. I want to move to, I'm trying to think of what we've talked about now. Specifically as it relates to compensation, I know, Judge Moore, you asked that the statute, once again, which is what our arguments are premised on, the plain text of these statutes does not provide any limitation in the means of compensation. In fact, the statute specifically addresses the idea that someone may be compensated in a way that is non-monetary or non-physical. And so in this case, where Dr. Hellman specifically said that the defendant in this case would receive a benefit, that he could use the number of ultrasounds he was alleged to have conducted to obtain either a type of certificate or future employment based on that representation, we do believe that was compensation that was provided to him. In addition, I think the thrust of his argument now on appeal is that there's an inherent benefit to doing these, to just get the experience to do so for an educational benefit. And so under the plain text of compensation as it's defined in the statute, I do believe that applies here. I wanted to push back on the representation that there was never any specific diagnostics provided at these procedures. If the court views the videotapes of State's Exhibit 1 and State's Exhibit 2, you can see the defendant specifically providing a diagnosis as he's conducting the ultrasound procedure. It may not be the case that in both of these circumstances the defendant was at the end saying, okay, here is a summary of the diagnosis that I am providing. But as he's going about and conducting the procedures, he's commenting on, i.e. diagnosing the victims as he's providing that ultrasound procedure.
When you say diagnosis, what do you mean? Is he just describing what he is seeing, or is he saying you have potentially this problem with this area of your body?
So it's not inclusive, but it's exclusive. He's saying things to the extent of like, I'm not seeing X, Y, or Z, which, the things that he,
So you would
elicited them to
say
come here before.
he's definitely engaged in something that seems like differential diagnosis, where he's saying, I'm ruling out these things.
Absolutely. In fact, he specifically tells them, after he's done with the procedure, he provides them with printouts of pictures that he's provided. He gives them I believe it's like a pamphlet referencing the procedure, describing the things that may or may not have been seen. That, by the way, the pamphlet was not presented as evidence, but it was referenced, the
It's in
content.
testimony.
Correct. Specifically, with regards to at least one of the victims, he also asked them to set up follow-up procedures, and he says specifically to see if there was anything that had developed and to compare the ultrasounds. So this meets all of the hallmarks of someone who he's not doing it for educational purposes. He's representing himself as a doctor who will be standing in. I realize throughout the course of this, he's representing himself as, this is part of a training program that I'm doing now. But there can be no doubt that what he believed he was providing to these victims, and what the victims believed that they were getting, was an examination by a doctor. That I think comports with the testimony that was provided by the victims of what they believed they were perceiving and why they decided to go through with the procedure in the first place. Having already addressed, I will also say it does appear in the record that they refer to him as a doctor. Although I want to address the fact that the statute says specifically that he doesn't have to use the term doctor. The use of any words or any phrase in any combination that has the intent to entice that person into believing that they're engaged in the field of surgery and medicine is sufficient to meet that. It's prima facie evidence of that intent under the plain text of the statute, which I think ultimately goes back to what we talked about at the beginning of my oral argument, which is, if the question is, can I go out and call myself a doctor? I think that's a distinctly different question than what we're faced with here, which is the use of words or phrases to entice someone into believing that you are engaged in a specific field when you are in fact not. And so specifically with regards to a resident or something, there may be confusion or colloquialisms around the term like resident doctor or an MD. But as the statute is risen, it doesn't really matter exactly what you say. I can go out and say I'm a resident doctor, and even if that's true, I still am not permitted to hold myself out as being able to engage in the practice of medicine if I don't have the certificate or license to do so. So I believe in the record, the victims say that he held himself out as a doctor, period, full stop. But even if he held himself out as a resident doctor, that is not sufficient to entice these victims into coming to his house and being victims to these examinations that were not covered under his certificate. And I believe the testimony of the two doctors in this case laid out specifically what those requirements allowed him to do. And they are, as he told the Ohio State Medical Board, he was absolutely outside of the bounds of that certificate.
Who said that?
That was Dr. Linenger. Well, the defendant is the one who said it to Dr. Linenger.
Okay, and Dr. Hellman, the appellant seems to characterize his testimony as almost helpful or forgiving towards the defendant in this case.
Dr. Hellman was, I would agree with the characterization of opposing counsel's characterization, but I don't think that Dr. Hellman was a mentor to him, but I believe his testimony was consistent that what was done here was inappropriate. I mean, Dr. Hellman testified at length about the requirements and the expectations of people generally within this.
Did he testify that any resident in his experience as someone who was in the educational program at the university ever did this kind of off-the-premises sort of examination as a resident?
No, and I believe the representations that opposing counsel has made are inferences that because he said that educational opportunities exist, that must mean that there are these other people who have done these things, but there's nothing to suggest that in the evidence. And I believe specifically Dr. Hellman testified that even for those educational opportunities, I believe he testifies something to the fact of they always have to be under supervision. Sometimes that supervision might even be telephonic or video supervision, or these might occur in the field in some place, but they're always done.
But the gist of it is somebody has to be supervising the person who's in training.
Correct, absolutely. And to answer your question about Dr. Linneman's testimony, he represented Saunders' admission to the board as admitting that the ultrasounds were, quote, outside of the scope of his program and that he was not doing it with the sanction of his physicians at UC, end quote. I'm out of time, so unless there's any further questions.
Thank you. You have 3 minutes left.
Thank you. Testified that no discussion of a benefit to him was ever done by Mr. Saunders. He said it would help him learn. He did it for a friend. This idea that he was enticing people into some sort of these people were friends. They may have felt later on betrayed or uneasy about what occurred, but they were all friends. That's what they referred to him as a friend. Training to be a doctor. I volunteered for his training.
If a graduated JD student with a temporary certificate but who had not passed the bar wrote a contract or a will for a friend,
Yep.
do you think that would be the unauthorized practice of law?
Absolutely. Do I think that somebody who has a practice, the temporary practice, decides to tell a bunch of friends, I have a trial coming up, or I want to be a better trial lawyer, so I want to practice doing a cross-examination of you, and then we do a cross-examination of you in your house or in my house, I don't think that's the unauthorized practice of law. I think that's training to do it, and I think the setting and the purpose is what's the difference. And that's what Dr. Hellman noted, was the difference between educational use of the ultrasound versus the diagnostic. And what he told the board was what the defendant in this case did was reasonable. What he said was, he did not tell him not to do those. What he did say is they sat down and talked, he and Dr. Saunders, about how to use the butterfly device and how he could get better at using it off premises because you can't practice on premises. So what I'm saying is there is a big difference between the practice of medicine, doing a procedure, cutting someone open, stitching somebody, giving a diagnosis, and instead narrating what you're doing at the time you're doing an ultrasound. I'm going over the heart now. I'm going over the abdomen cavity. I'm now going over your leg.
Well, that's the question. Is it just narration, or was it telling them that everything's looking okay?
They did not say that they ever got a diagnosis. They never, all they said is he was talking to them, asking them permission, and they both said that. As he moved from area to area, he asked permission. Is it okay if I go here
What
next?
does the video show him telling them that this is looking okay, and this is, because that would be a diagnosis, right?
I would agree with you on that.
Yeah.
But
Does
to
it
sit
show
there and
that?
say that we can do a second one 6 months from now and compare the two,
Right?
doesn't, if he sees something, then maybe he does. It would be no different than any other setting, but someone has to be able to, outside the clinical setting of where you are treating actual patients, get better at some of the other procedures that have nothing to do with the actual treatment of a patient. And that is part of what was going on here. If Dr. Hellman said he did not say don't do it when he explained what he was doing. It talks about direct and indirect supervision. So what I'm saying is you have, and I guess I'm done in case anyone else has any other questions. I saw the 3 big zeros come across, so I'm sorry.
That's all right. I think we don't have any more
See,
questions.
it worked.
Yeah,
The big
thanks.
zeros told me to stop.
You know, the lights never work for anybody, but the zeros sometimes work.
I always cover the lights with it, that's why I never saw them.
Oh,
I'll be happy to move.
sure, we can look into that. I'm sorry, I didn't even catch that.
That's okay.
Yeah,
It was the last thing. Ask that that be seen.
I'll see what we can do on that one. Yes, okay.
Sorry.
Thank you. Okay, all right. So, the next cases we have are, Zuriach and Hamilton v. Durrani. Zuriach and Hamilton. Mr. Williamson, how much rebuttal time would you like?
4 minutes, Your Honor.
Whenever you're ready.
May it please the court, I want to address 2 issues in this case. The statute of repose is applied to Ms. Hamilton and the consolidation of these cases. I'm happy to start whichever spot the court would prefer.
However you want to do it.
I think the statute of repose we can treat fairly quickly, Your Honor. There's, I think, no dispute about sort of the timeline. If not told, the statute of repose for Ms. Hamilton would have expired about a year before she filed her very first complaint. Before she filed the operative complaint in 2016. So the question is whether the statute of repose was told. Under Elliott, it would have been told by Dr. Durrani's absence, but Elliott has been overruled by the General Assembly. And the question, I suppose the two questions are, number one, is Elliott still good law? I think the General Assembly has clearly communicated in HB 179 that it's not. And the court does not actually have to engage in any retroactivity analysis.
Why are you saying that Elliott has been I think the
The General Assembly did.
Well, the General Assembly amended the statute
Well, so.
in light of the Supreme Court's interpretation of that statute, right? So I don't think they can overrule the Supreme Court of Ohio. I think they just amended the statute.
No, Your Honor, so the General Assembly used those words, and that part is important here. The General Assembly said our specific purpose is to overrule the decision in Elliott versus Donati.
Yeah, but can they?
So, Your Honor, I would say that question doesn't actually matter here.
Okay.
Because what you're really asking, if the court is engaging in retroactivity analysis, what you're asking is whether the General Assembly has signaled that it intends for its statute to be retroactive.
Right.
And its use of the phrase overrules communicates that it's intended to be retroactive. So in the Peerless Electric Company versus Bowers decision, the Ohio Supreme Court itself says, when we overrule a decision, that phrase overrules indicates that the former decision is not good law and was never good law, and that it is retrospective in effect. Just to say, the Ohio Supreme Court has already said, when the Ohio Supreme Court uses the word overrules, it's retroactive. The General Assembly is simply adopting the language the Ohio Supreme Court itself has used and would use to accomplish the same thing.
Is there another situation where the General Assembly overruled an Ohio Supreme Court case?
No, Your Honor, I think we point out in our brief, like the use of that phrase is rare, but retroactive statutes
Has it
are rare.
ever been used before?
As far as I'm aware, not by the General Assembly.
Okay. But you're saying that the use of that phrase means that they intended for this to be retroactive?
Yes, Your Honor. Again,
Okay.
because, Van Fossen, which is sort of the fountainhead retroactivity decision, does not prescribe a specific form of words the General Assembly has to use. All it directs is that the General Assembly has to give a clear signal. And so one of the things I think we distinguish in our brief is that something like abrogate, respectfully disagree with, those are phrases that do not communicate retroactivity.
The way I read it is that the Ohio Supreme Court interpreted the law and said what the law was. And then the General Assembly decided to amend that law.
No, Your Honor. The General Assembly said the Ohio Supreme Court was wrong. It's not simply.
They didn't like the interpretation, but.
Your Honor, I think here, there is sort of an important separation of powers point to make here, which is we're not talking about the interpretation of the Ohio Constitution. We are talking about the interpretation of a statute. The General Assembly said to the Ohio Supreme Court, you interpreted our statute, our work, incorrectly. Your job, Ohio Supreme Court, is to give effect to the intent of the General Assembly as we communicate it in statute. And you did not do that here. You got it wrong.
I just think in every other situation where the General Assembly is not happy with the Ohio Supreme Court's interpretation of a law, they then amend the law. That's what they do.
Yes, Your Honor. And most of the time when the General Assembly does that, it does it with prospective effect. And what that communicates is we don't like the outcome. You have identified a problem with the statute. We don't like the outcome, but it's very rarely that the General Assembly says you actually got the interpretation wrong. There's a difference between you got the interpretation right and we don't like the way that turns out, and you actually got the interpretation wrong in the first instance. And what you get in overrules is we think you got it wrong in the first instance.
Did they change also the language of the statute then, other than saying expressly overruled?
So they changed the language of the saving statute to provide explicitly that it does not apply to statutes of repose, and gave a list of statutes of repose that it doesn't apply to. And I think very important for the court to make note of, the General Assembly didn't touch the statute of repose itself. It simply amended the absent defendant saving statute, specified that it does not apply to statutes of repose, and then the third item in that bill, HB 179, is the intent of the General Assembly is to overrule the decision in Elliott
So
versus
it,
Durrani.
it actually changed the law in response to the Supreme Court decision and then said, this is our intent. I mean, it actually changed the operation of the statute.
So, Your Honor, I think if you read particularly statements of the members of the legislature who drafted the statute, what they say is, we're not changing the operation of this absent defendant savings statute. It was actually the Ohio Supreme Court that changed the operation of the savings
But they
statute.
clarified the language to make clear,
That the Ohio Supreme Court was wrong.
right, but they actually changed the words of the law in addition to expressing their intent about what they thought the Ohio Supreme Court did incorrect.
Yes, Your Honor, you will not find, I think, anywhere in the history of Ohio legislation or the Ohio courts, a statute that simply says, we overrule the decision of the Ohio Supreme Court simpliciter with sort of no change in statutory language.
Have you looked anywhere in any other jurisdiction to see if legislatures are overruling Supreme Court rulings?
We didn't, Your Honor, and I think the principal reason for that is Ohio's retroactivity statute and the jurisprudence around it is, I won't say unique to Ohio, but we just didn't figure that, Texas was going to be terribly helpful to me.
But we're looking at what you're saying is that when we do this test on retroactivity, we have to see if the General Assembly made a proclamation indicating that it intended this retroactivity. And you're
Correct.
saying the proclamation that was made was them saying, we overrule an Ohio Supreme Court case, right?
Correct, Your Honor.
So I'm just wondering if any other court anywhere else has ever said that that equates to a proclamation of retroactivity.
No, Your Honor, I don't have that case for
Okay,
you.
just curious.
And is there anything that would allow the General Assembly to overrule the Ohio Supreme Court?
Your Honor, in a certain sense, I mean, almost every change to the law can be treated as overruling decision if the General Assembly disagrees. But I come back to, that's not actually the question that you have to address here.
Well, my
You can
question-
believe that the General Assembly cannot overrule a decision of the Ohio Supreme Court.
So that becomes surplusage then, that the phrase, we overruled the Ohio Supreme Court is meaningless because they can't do that.
Absolutely not, Your Honor. The only question this court has to ask, and only question you have to answer is, when the General Assembly said, we overrule Elliott versus Durrani, did they signal that this statute is meant to be retroactive? You don't have to believe that the General Assembly is allowed to overrule the Ohio Supreme Court. All you have to do is ask, what was the General Assembly trying to signal by its use of this word?
So why would we have to do that? Why wouldn't they just say, we expressly declare this is retroactive?
Your Honor, there are almost zero statutes where the General Assembly says that.
But there's more than zero, right?
Your Honor, I always sort of hesitate to deal in absolutes from the podium, but I cannot think of a case where the phrase the General Assembly used is, this statute is intended to be retroactive. You will see statutes like...
They had to know this was going to come up in the context of these particular proceedings, right?
Yes, Your Honor, they did in fact know it was going to come up. And again, this is another thing we point out in our briefs. The legislators who drafted this statute are practicing attorneys. They used the language that the court would use if it intended to retroactively overrule a decision. All the General Assembly has done is tracked the language it would expect the Ohio Supreme Court to use. In fact, if this case goes to the Ohio Supreme Court and the court decides, rather than engaging in the retroactivity analysis, we're just going to overrule Elliott, they're going to use that specific phrase, Elliott versus Durrani is overruled.
But that's the court's language. The General Assembly,
Exactly, Your Honor.
but the General Assembly is required to indicate that they intended for their new law to be retroactive. And there's no language that indicates that. They're just, as you point out, parroting the law that a court would use, and they're not a court.
And my point, Your Honor, is the General Assembly is signaling its retroactive intent by using the very language that the courts it is writing to would use to signal retroactive intent. They are trying to eliminate the translation problem and simply speak about Elliott versus Durrani the same way the Ohio Supreme Court would. rather than, again, all we're doing here is trying to speak, it is the General Assembly trying to speak judicial language about a decision that they're overruling and to give retroactive effects to the statute without sort of forcing you into difficult translation work.
You're at your time if you want to reserve your 4 minutes. I know that went fast.
It did. Thank you, Your Honor.
Smaller papers to reduce trying to drag that around. Morning.
Morning.
So, in listening to your questions, the first thing I'll tell you is that the word overruled, when you look in Webster's dictionary, talks about what it means in the judicial sense versus the general sense. So their use of this word overruled, they don't have a right to use that. There's a separation of powers issue here. If they want to amend a statute, amend it. And if they want it to apply retroactively, they don't have to be obtuse using the word overruled. That's just lawyer talk to come up with something to say when they could easily say retroactive versus prospective instead of this obtuse idea that somehow the separation of powers don't apply, they can overrule what the Supreme Court does. And that, to me, appears to be nonsense based upon the state of constitutional law, the separation of powers, both in the U.S. Constitution and in the Ohio Constitution. But we have the issue of, did Eliot grant substantive rights to these parties? And it did. When Eliot was decided, substantive rights attached to those patients, and they then had a right to proceed with a cause of action. Applying this amendment retroactively extinguishes rights the Supreme Court gave them, and therefore it can't be applied retroactively.
Well, the Supreme Court interpreted the current law as giving them those rights, right? In Elliott.
Exactly.
It was their interpretation of the law as it stood at the time.
And based upon the fact they are the Supreme Court, they made that determination, and those rights vested based on their interpretation.
Is there any case law about whether statutes of repose or limitations or the saving statute are substantive or remedial?
Yeah, the statute of repose is substantive. It's cited in their brief. They cite it as substantive because it gives the doctors a right to be free from litigation after 4 years. But I say it also gives the patient the right to have a prescribed time that they can pursue things.
What about not the statute of repose, the saving statute in particular? Is there any case law or any court that has spoken to whether or not the saving statute is?
Well, I think you get into that definition of when can something be considered remedial versus substantive. And in the case of even a remedial statute, if it's applied in a way that extinguishes a substantial right, it can't be applied retroactively. And there's ample case law. I'm sorry I don't have a cite just off the top of my head, but in preparing for today, that was one of the issues I was thinking about. And there is substantial case law because it all comes down to whether retroactivity extinguishes a substantive right. So you would have to find, to agree in the general sense with this argument that they make, that their rights didn't vest upon the Supreme Court's decision in the motion to reconsider. They didn't vest. Well, when would they vest if the legislature never acted? They had to have vested at the time of the Supreme Court's proclamation. So I don't see how they get around that. And I think that the way the legislature probably thinks about this is, okay, well, Durrani victims, because this is a unique situation. You cannot just look into Ohio law and find a place that 200 to 500 people are involved in litigation with the same general set of circumstances with one singular doctor and his company. And you can't go to other states either because they don't have, there is Texas, but it's a small group of people. They made a Netflix series about Dr. Death, but it doesn't have nearly the breadth that this case has. So it's not an easy thing to say, well, there are Durrani situations all over the country, and we can look and see, since we've got a sort of a first-time mass tort litigation against the doctor, we can look and see how Massachusetts handled it or Arizona. It's not the case. So you got to fall back on these, the issues that you're raising, which are, basic interpretations of how people acquire substantive rights, don't have substantive rights in a situation, what the word overruled means. My clients also have a right to a jury trial. And that's a right they have. But we're in a situation, because he did say he wanted to talk about consolidation.
We asked him so many questions.
What's that?
We asked him so many questions. He ran
Yeah,
out of
no, I know, but I just want to mention, in case that comes up, that really Rule 42 is somewhat administrative in nature. And you take away consolidation from this situation where you can put people in categories and consolidate cases. You're always going to find differences. Even in an example they used 2 weeks ago in here, well, it's not like the pharmacist put 2 pills in instead of 1, and somebody should have only taken 1, but they took 2, and it happened over and over again. Everybody's reaction to those pills is going to be different. Somehow they thought that was consolidatable and different than this, and it's just not. So this is, people had results of spinal surgery, and they are generally grouped by what area of the spine, but they're all spinal surgery. But on the constitutional issue, these people have a right to a jury trial. I've had over 100 clients die waiting for their trials. And if you overrule consolidation, it will take another 10 years to try these cases, because we can only, in a singular case, based upon how the schedules work out, can only try 40 of these a year.
Like, so in this particular case, I mean, the plaintiffs were very different in age. They were very different in what was wrong with their bags. Like, what was the common question of fact here to group
Lumbar
these?
fusion. Lumbar fusion.
So lumbar fusion was the common question.
Yes, and it doesn't matter what age you are. A T-lift is a T-lift, whether it's done on someone 19 or 75. A D-lift is a D-lift. These are types of fusions. Whether you're 20 or 45, it's a procedure, and it's on the spine. It's easy to think about, well, could you consolidate a case where a doctor is doing the absolute wrong broken arm procedure, and there are people with left operations and the same wrong procedure on the right? Of course you can't. A procedure is a procedure. The bone is the bone. As I said 2 weeks ago when I was in here, if I threw a set of lumbar vertebrae on the floor, I would challenge anybody to pick them up and tell me which one's L5, which one's L3. They all are physiologically the same. And you don't get into physiologic changes until you get to C1, C2. And the only difference between vertebrae and the thoracic spine is the fact that ribs are attached to them. Otherwise, if you chop the ribs off, they look exactly the same, up and down.
But you have argued previously that all that really matters in your mind is that it was spinal surgery.
I agree.
I mean,
But
that would be the common question for you.
Right,
Does
but
it
I can-
matter what type of spinal surgery or where on the spine?
And that's exactly my point when I'm saying T-lift versus D-lift, 45 versus 75. It's all spinal fusion. It's all on the spine. And even when somebody has a level where they get a fused level and then they get a decompression, a laminotomy, discectomy, foraminotomy. Those are all elements of what ultimately becomes a spinal fusion if it is unstable. A DLIF is doing the same decompression that a decompression laminectomy foraminotomy is doing. The only difference is they're putting instruments in place to hold the bones steady while they fuse, where in the other situation, they don't need to do that because it's not unstable.
So
But it's
in-
all
in
part
this-
of the same thing.
And I'm trying to remember in this case, I'm impressed how you're trying all these cases and keeping these separate. In this particular case, I guess in every case, you guys argue that the surgeries were unnecessary. Like, that's always an
Right.
argument.
It's not an argument about should he have chosen a DLIF or a TLIF. The argument is there shouldn't have been any surgery.
And then,
that's a
so that was
combo.
the case here, and then also that the surgery was improperly performed. It's both of these arguments that you're making.
Well, the improper performance is usually related to a screw that got misplaced,
Correct.
not that the procedure itself was improper. And the screw being misplaced is more about being a pain generator than you didn't do the surgery correctly. The surgery called for screws in the pedicle.
Right, so it was, there should never have been a surgery, and then once the surgery was done, it was done incorrectly.
Now, the surgery was done correctly, but in pedicle screw placement, they put them in too far. So the
But your experts say that that was below the standard of care, don't they?
Yes,
So there is like this prospective knowledge that these are going to be argued as surgery unnecessary, but then the details of the malpractice, they might actually change in the testimony that's given at trial as between the two different patients,
well,
or three different patients. Like there might be three different outcomes, like, and you're only going to know that when you get to trial, right?
not necessarily, well, in a way, I think you're right, but the deciding factor for you on review is most likely interrogatory number 2. Because interrogatory number 2 tells you exactly what the jury thought the malpractice was. And you can look through this, and you can see exactly what they're talking about. And as I view it, it looks like this one notes the screw, but otherwise they're talking about unnecessary surgery as the primary reason that they made the findings they find. And it's interesting also where they make the argument that the consolidation causes the jurors to just lump everybody together. Well, interrogatory number 2 proves that's not the case. And the interrogatory, I think it's number 11, on damages proves that they're not just lumping things together because all the numbers are different.
So you're saying in a way, even if we think the consolidation was improper, it was harmless based on the interrogatory and the differing verdicts.
Yes. And I think that's clear when you look at this and you look at how the jury analyzed the cases in terms of what damages they awarded to who, how much, and in what categories. They're all different. Now, they point to the fact that you get punitive damages awards that are the same. Well, what they fail to discuss is that's an element of punishment. That's not necessarily related to whether somebody got $400,000 or $250,000. The jury across the board, and they too describe the basis for the punitive damages in an interrogatory, is that they're sending that message to the medical community and they're punishing the wrongdoer. So it's not outside the realm of believability that they would punish him for doing an unnecessary surgery in the same amount for each person. It makes perfectly good logical sense. If you have no other questions, that's pretty much everything I heard to address.
All right, thank
Good.
you.
Thank you.
All right, Your Honors, 20 seconds on repose, and then we need to talk consolidation. Judge Nestor, to answer your question about whether there's case law and whether a saving statute is remedial, yes. Wilson versus Durrani, paragraph 11, we cite that in our brief. You can divest someone's vested rights. That's what the Supreme Court was talking about in the statute of repose cases in Ruther and Antoon. Like, that was the question. And finally, there's no rule in the legislature or in any case that says the General Assembly can't use a particular word. Certainly that it can't use a word that the Ohio Supreme Court itself has already defined. Now, that was 40 seconds. Consolidation. First of all, the delay in these cases is plaintiffs' doing. This is something we detailed for about 12 pages in our Jones brief. But many of these plaintiffs would have been to trial already had they just kept their original Butler County dates. Like, the delays in these cases are largely plaintiffs' doing. You asked Mr. Statman, what's the common question in these cases? And his answer was lumbar fusion. Where in there did you see a question? Where did you hear a question mark? I will show my age and say, is the question in the room with us? Lumbar fusion is not a question. The question of whether the lumbar fusion was necessary is going to vary from plaintiff to plaintiff. It is what the Supreme Court said in Tyson versus Bofeco, is a classic individual question where the proof is going to vary from plaintiff to plaintiff in each case. If that's what's happening, you have an individual question, not a common one. Mr. Statman mentioned the jury interrogatories where the jury describes sort of what it's finding. I can't think of a case, with the exception of Stevenson and the Tayeb testimony, where the jury interrogatory describes the trial errors, or where the court has said, we're not going to correct an evidentiary error, we're not going to correct the trial error, because the jury interrogatory doesn't say, and we relied on this particular error. The errors are what help the jury get to the conclusion that shows up in the interrogatories. They shade credibility decisions that the jury is having to make about witnesses. They shade the inferences that a jury is making as it is trying to review and evaluate the evidence. And
How do we know that? How do we know that the jury was impacted the way you're describing it?
So, Your Honor, part of it is that we've built a lot of guardrails around preventing what happened at this trial. So we have rules about introduction of evidence of other bad acts. Why? Because we simply know that stacking bad act after bad act is going to lead a jury to think, okay, well, the second person or the third person or the fifth person who tells me unnecessary surgery, I got to believe where there's smoke, there's fire. In fact, we had a juror in a case we argued about 2 weeks ago who said exactly those words, where there's smoke, there's fire, with multiple plaintiffs.
And that's the kind of evidence we would need to demonstrate actual prejudice, correct? A statement like that.
No, Your Honor.
How do we conclude that there was actual prejudice?
I would point you back to Stevenson. So in Stevenson, you have solo plaintiff in the introduction of a statement that Dr. Durrani had been sued previously. There is no reference to that statement in the jury interrogatory. You don't have a juror saying, I found him liable because I heard he'd been sued before. You just have the introduction of that statement, that Dr. Durrani has been sued. This court had no problem ascertaining that in a medical malpractice action, the most prejudicial thing you can say is the doctor probably committed malpractice in a different scenario. And that was enough to find prejudice. The court was not looking for, and the court rarely looks for, a juror who stands up and says, hey, that trial error you're thinking about, that affected me. There are almost no cases where like that kind of direct one-to-one conversation happens. But we simply know this about human psychology, and it is the reason why the rules of evidence and Rule 42 are structured to prevent injecting other cases and outside influences into what is happening in a single particular case.
So if an error like that occurs, is it automatic that it results in prejudice?
So when you've got an error that's something egregious like we're in a medical malpractice action and I'm telling you the doctor's been accused of other additional malpractice, you certainly don't have to look very hard to find that that's prejudicial. I hesitate to say that it's automatic, but I can confidently represent, the reporters are pretty full of cases where that error occurs and the court says, look, in a malpractice action, this is simply highly prejudicial evidence and we're not confident the outcome is the same if that evidence gets excluded. And again, that's what this court did in Stevenson. It's what it's done in almost all of the Durrani Collage cases. It's that inference. This doctor has been accused of malpractice here. You are now telling the jury it wasn't just here. That's enough. We simply do not permit that kind of evidence. And what you got here was not just an off statement in a collage, but half of the case is he committed malpractice here, and he committed malpractice here too. I see that I'm out of time, but if you have more questions, I'm here all morning.
I think not for this case. It's going to be brought up in this second case as well, so.
Thank you, Your Honors.
I guess you're not arguing that one.
I'm not. I will move over to second chair
Okay.
for my colleague Willie.
All right, so the next case is Wiseman versus Durrani and Jones versus Durrani. Ms. Rigby, would you like to reserve some rebuttal time?
I would like 3 minutes for rebuttal.
Are you ready?
May it please the court, Lillian Rigby on behalf of appellants Dr. Durrani and Cast. Dr. Durrani and Cast raised 8 issues for review in Ms. Wiseman's case and 6 for Ms. Jones. But for the purposes of this argument, I will just focus on 3 issues. First, appellees' withdrawal of their fraud claims. Second, the statute of limitations in Ms. Wiseman's case. And finally, consolidation. I'd also like to draw this court's attention to the issue of set-off in Ms. Wiseman's case. Under Fenner, this court should remand Ms. Wiseman's case to the trial court to determine the proper amount of set-off. As for the first issue I'd like to focus on...
Okay.
As for the first issue I'd like to focus on today, in both cases, the jury only found Dr. Durrani liable for fraud. These were fraud-only verdicts. And in December, appellee stated that they no longer challenge the fraud claim as it relates to these cases,
So wait, which plaintiff was fraud only?
both of them.
Both of them, okay.
So this means that appellees are no longer defending the verdicts in these cases. This means that this court should enter judgment for Dr. Durrani. If the court is unwilling to enter judgment for Dr. Durrani, then this court can vacate the judgment and remand the cases back for trial on the fraud claims.
I guess I'm trying to understand how that works. Jury found fraud. How do we, with them withdraw, I don't understand how we fix this. How we do anything. They withdrew their fraud, but we denied it, right?
The procedural history on this issue is a little tricky. Appellees filed a motion to dismiss, but in that motion to dismiss, they didn't just file a motion to dismiss. They also expressly stated that they no longer challenge the appeal as it relates to fraud. And so this court then denied that motion to dismiss, then heard an argument on the issue, and appellees then filed their withdrawal of the motion. But they never expressly disclaimed their statement that they no longer challenge the appeal as it relates to fraud. So,
But they're here defending theoretically the verdicts and the judgments in the case.
I can't speak to I can only speak for what appellees have filed with the court. But to the extent Appellees may try to distance themselves from those previous filings. I think that gets at some of the policy rationale behind why this court should hold appellees to their briefs. Dr. Durrani incurred prejudice and time, expense, and this court spent time and resources on these issues. And appellees shouldn't be able to file motions like that. Appellees knew that they had the right to assert the fraud claims and to defend them, but they acted inconsistently with those rights and declined to defend them. If there are no more questions regarding fraud, I will move to the statute of limitations issue. The statute of limitations had already run by the time Ms. Wiseman first filed her case in Butler County. Therefore, judgment should enter for Dr. Durrani. Ms. Wiseman had her surgery in December 2009. She testified at trial that something was wrong with the surgery almost immediately after the operation and definitely within 6 months of the surgery. The statute of limitations was technically proposed because she didn't turn 18 until April 2010. However, she last treated with Dr. Durrani in November 2010. This is her last appointment with him. Medical malpractice actions have a 1-year statute of limitations, so Ms. Wiseman had 1 year from the later of the date she turned 18 or the date that she discovered her injury. The plaintiff's discovery date can be stayed if the patient continues to treat with their doctor. She continued to treat with Dr. Durrani until November 2010. So reading the facts maximally in Ms. Wiseman's favor, she had until November 2011 to file her claims. However, she didn't file her case until November 2013, almost 2 years too late.
And that was in Butler County.
That is correct. Assuming no further questions, I will move to consolidation. These cases were improperly consolidated. Consolidation is most troubling here because plaintiffs' counsel and plaintiffs' experts put the cases in conversation with each other during the trial, and because the trial court here justified the consolidation based in part on the differences between the plaintiffs. Dr. Durrani has asked that this court grapple with what is the definition of a common question of law or fact under Rule 42, but here the trial court said that the differences could support. The trial court initially based its decision on judicial economy and said that the defendants were the same, the experts were the same, but then it's a key other part of that Rule 42 quote-unquote analysis. The trial court said that the issues in the case were somewhat similar. Not even similar, definitely not common, somewhat similar.
Well, what do you say if they both cases were basically fraud verdicts? Doesn't that kind of prove the point that they were similar?
Fraud and most claims require individual inquiry. There are multiple elements to fraud. One of those elements was, did the plaintiff or patient here reasonably rely on the alleged misrepresentations? And the circumstances that may have led Ms. Wiseman to allegedly rely on representations by Dr. Durrani are different than the circumstances under which Ms. Jones may have relied. So no, the common claim of fraud is not enough to join the cases. And I would also point the court to the fact that Rule 42 and Rule 23 have the same language of common question of law or fact. Rule 23 has been interpreted to mean by the Supreme Court that just because plaintiffs have suffered a violation of the same provision of law does not mean that there is a common question.
Well, appellees are arguing that the common issue is spinal surgery. Why is that not a common question?
That is still too broad. The question cannot just be, did the plaintiffs have surgery? The question is, was there a tort associated with that surgery? Did Did the plaintiffs need the surgery? Was Dr. Durrani negligent in the performance of the surgery? And that analysis is different for each plaintiff. Here, especially, the surgeries were very different. These two plaintiffs saw Dr. Durrani at different stages of their life with different conditions, and they had different surgeries and different outcomes. So just the fact that they had spinal surgery cannot be enough.
You said the trial court relied on the differences. How so?
So I can read from the transcript if you'd like, but the trial court said that the trial judge said that he wanted to make a record of Rule 42 analysis. He walked through that analysis of judicial economy, somewhat similar issues. Dr. Durrani's counsel then objected. And in that objection, counsel listed just some of the material differences between the plaintiffs. And in response, the trial court stated, counsel, don't those differences help justify consolidation and ensure that the jury won't confuse the issues? Dr. Durrani then walked through stated that he would be unfairly prejudiced by the consolidation.
In some of our cases, it seems like we don't have any rationale. In this case, it seems like there is some rationale. Why shouldn't we defer to the rationale of the trial court?
I would point the court to look back to its past analysis in the mandamus action. Dr. Durrani actually brought that action in part based off of the consolidation of these cases at issue, that fifth trial sequence. And in the dismissal order in that mandamus action, this court directed Judge Reese to conduct analysis into common questions of law or fact, and even opined that consolidation may be less appropriate in medical malpractice issues or medical malpractice cases because of the issue of prejudice and propensity evidence.
Did you say when you started that one of the issues was the experts were putting these cases, like comparing these cases with each other? Is this something that's been is unusual compared to some of the other consolidation cases that we've had, or? I mean, just could you explain that a little bit more?
I believe so. Plaintiffs at the beginning stated that some of the issues would be common across both the cases, but when Dr. Saini testified in Volume 5, I believe, page 128 and 29, he was walking through imaging studies for Ms. Jones's case, and he referenced on multiple occasions the prior study being Ms. Weissman's case. And he put those two cases in conversation. Dr. Durrani promptly objected and stated as a basis for the objection that Dr. Saini was comparing across cases. And the trial court overruled the objection, and in that overruling stated that he thought that the jury could keep the issue separate. And I have not seen that in some of the other consolidated cases.
When the trial court said that, did he direct his comments to the jury, or was it to the parties? Sometimes you might overrule an objection and then direct the jury to make sure that they keep the cases separate. Did anything like that happen?
No, there was no comment directly to the jury. The trial court did,
No limiting instruction?
there were no limiting instructions there.
Was there ever a limiting instruction that the jury should keep these cases separate?
I counted 3 instances, twice at the very beginning, especially during voir dire, because one of the jurors inquired why are these cases separate? Why doesn't each plaintiff have their own trial? So the judge walked through that they were separate on a couple of occasions, and then right at the end in the jury instructions.
Was there any reason we would need to believe that the jury wouldn't follow the judge's instruction?
Just because the jurors may have been able to separate the facts may not have meant that they were not prejudiced. This was a very close case. The 6th juror had to be persuaded for each plaintiff, and they only found for Dr. Durrani on one of the claims.
Is that indicative of that they were able to keep them separate?
I do not think so. Any juror could have been. The juror heard that Ms. Weissman had more pain after her surgery. and that could have affected their analysis for Ms. Jones.
Well, you're at your time if you want to reserve your rebuttal time.
Thank you.
One of the problems I've repeatedly found is that since appellate counsel was not there, their interpretation of things in the record oftentimes don't make sense. And what I just heard, I disavow that 90% of these factual allegations that were just discussed occurred. First of all, Dr. Saini never puts up a comparison of patient A and patient B. Doesn't happen. He
But
has,
during the questions, the record reflects sometimes, in this case in particular, it does reflect that there is what could be charitably called cross-contamination between the cases. They're not kept distinct.
well, they are because we do the direct examination of expert one. We do the cross-examination of expert one, and then we do the redirect of expert one. Then we move on to the next expert in the same case and do the same
So, like, for
thing.
example, when she was saying in the prior case or the prior study, and he is referring to not some prior study, but to the other plaintiff, that seems like at least some comparison is taking place as between the two cases that are right in front of the jury.
In a rare set of circumstances, a witness, an expert witness might say something like, well, you saw those films, but in this film, we're looking a level down, we're not looking a level up. They're not comparing their ultimate opinions to the two different cases. They may be instructing them, just like they instruct, my experts get the opportunity to instruct the jury on a general discussion of spinal anatomy. And so every expert that I call, well, I get to do it once. The first expert I call goes through the spinal anatomy and tells the jury, we're not going to do this 3 times. Because the judges said, we're not only going to not do it 3 times, we're not going to have the other side get up and repeat it. If they want to get up and point out some distinctions, great, but the spine's the spine. So they hear about a spine, discs, spondylolisthesis, ruptures versus bulging. They hear all that in a general discussion of what is the anatomy. They also hear a general discussion about what is a dermatome map, which I've talked about, and I don't remember if I talked about it with the 3 of you, but I did talk about it 2 weeks ago, because dermatome anatomy is similar in all human beings, and it says where the nerves intervene. So the lumbar spine innervates through the thighs, the back of the legs, down into the feet. Thoracic spine comes around the core, cervical spine, arms, neck, head. That's all common. And the judge doesn't believe that we need to do it 3 separate times. So
What do we do with the fact that in this particular case, and the judge, in ruling on whether the cases should have been consolidated, actually acknowledges that there are a lot of factual differences between
well, except that all factual differences aren't relevant to the analysis. As I said, a TLIF is a TLIF.
But he never gets into what the commonality is.
Well, what has not been discussed, and I've discussed it again before, but I don't know if with the 3 of you, is that each side submits a memorandum to the judge listing the cases in groupings and what has caused the defense or the plaintiff to group these people together. And so, you're right, they don't go through all the evidentiary facts.
Why were these 2 grouped together?
Why were these grouped together? Well,
We have a I know you don't think age matters, 17 and a 48-year-old with,
Well, age
Different
doesn't
issues.
matter. I mean,
Okay.
an appendectomy on a 13-year-old's the same as on a 25-year-old. These are not trained as age-specific surgeries. They just aren't. A T-lift is done on a 16-year-old and an 86-year-old. And what's interesting is there's no difference between a D-lift, a T-lift, and an A-lift, other than the approach. How does the doctor get to the spine? The operation itself is exactly the same. So
so are you saying that these two plaintiffs had the same operation?
they had lumbar surgeries, and one was at the L5 level on Weissman, and on Jones, it was L3-4 and L4-5. So they're all lower back lumbar surgeries. So, again, it's common issues of law or fact, not and. And they clearly have common issues of law because we have exactly the same jury instructions on the law in each case. In each
So
case.
I know you argue that, but it seems like then, like, if that's a common issue of law, then like any malpractice case could be consolidated.
Well, I'm glad you asked that because 2 weeks ago I discussed that same question. And you don't typically find on the street two lawyers that have a malpractice case that are not working in the same firm for two different plaintiffs. And they run into each other at the diner and say, wow, you got a case against Dr. Smith, I got a case. Why don't we put them together? It just doesn't happen. And this gets back to the fact,
Could they do that?
what's that?
Could they do that?
Well, there's a lot of factors we have to look at. We got to go back to.
Well, if it's both, if the, both of them have lumbar surgery malpractice claims against the same doctor, could they bring the cases together?
Could they? I guess if the court found that there were common issues of law or fact, they could.
Well, the question is really.
It just doesn't happen.
But like, it seems like the common issue of law there is it's a malpractice case with all the same jury instructions. The common issues of fact are particular to the circumstances of the surgery and the plaintiffs as they present.
I understand, but the
It
way
seems
that,
like these are like common issue of fact cases, not common issue of law cases.
except that the case is, it's an or. So you can't say it's, we got common issues of law, and even though the rule says or, we're just going to look at facts. You can't. That's not what the rule is. And the rule is also somewhat procedural and administrative in nature because there's no reason to consolidate cases.
It seems easier to consolidate cases when they are more factually similar. Setting aside the law side of this, the more factually similar the surgeries, the plaintiffs, their age.
Well, see,
Like,
this
the
court-
closer you get to someone being close to each other in presentation, the more likely it is to consolidate.
no, I don't agree with you, and I'll tell you why. Because demographics, this court said to me, I think it was 2 weeks ago, may have been an argument 4 weeks ago, that demographics aren't the issue. It doesn't matter if they're a man or a woman. It doesn't matter if they're 35 or 45. It doesn't matter if they grew up in Ohio or Kentucky. It doesn't matter. And so if you want to argue differences, and that's what they're good at doing, I could spend the next 45 minutes telling you why they're the same or why they're different. I mean, I can go down that list. Yeah, they're different ages. One was married, one wasn't. Their previous medical history took a different course, except then you got to add in Dr. Durrani across all 500 patients, never looks at prior medical history, even though they bring that up as a differentiating factor to try to avoid consolidation. So is it similar because he never looks at the past history? Or is it different because they all have different past histories? They don't look at that stuff. It's not part of the record. And it doesn't matter. You do the same. If I break my arm and I need a Hoffman's device to stabilize it, I'm going to get it, just like the Olympic athlete who broke her leg downhill skiing got a Hoffman's device.
But her damages might be a lot bigger than yours. And sympathy for her as an Olympic athlete might accrue to you as someone sitting next to an Olympic athlete.
Well, sympathy shouldn't be a factor, and they're specifically instructed they're not allowed to consider sympathy. So we have to start from the fact, unless there is something that is an objective, observable fact that didn't take place in the jury room, you assume that they are fulfilling their obligation to follow the law. And the judge repeatedly tells them in this case that even though they're consolidated, they're individual cases. He then goes on and says, we have provided you with notebooks with dividers so that you can keep case A, B, and C separate if you choose to take notes, but you are not instructed that you have to take notes. He reminds them continuously. They have 3 full sets of interrogatories. They have 3 sets of jury instructions because the names are all changed. So they get different set, because one case you're talking about Smith, one you're talking about Jones.
Before your time's up, can you get into the statute of limitations?
The statute of limitations.
Yeah, I would like to know why the statute didn't run. Your view.
The statute didn't run because the judge made a factual analysis related to that and determined it didn't run because of the issue of minority and the statute of repose and how that all translated into whether it did or it didn't. And interestingly, if you notice, in the JNOV motion that is brought, they do not raise the statute of limitations. They're looking for a judgment notwithstanding the verdict or a new trial. Now, why do you need a new trial if you're going to raise the statute of limitations? They abandoned that by the time they got to the judgment,
So
their JNOV
your
verdict.
argument is that this argument's waived now?
Well, I think it was never appropriate, and because it's a factual issue, not an application of whether this statute or that statute applies, it's an abuse of discretion rather than a de novo review.
Isn't it an issue of law? Like what did the judge below find some different cognizable event other than her last treatment day?
The judge ruled based upon the facts that were presented through both plaintiffs' entire testimony and made a ruling at the time that they made their motion that the
When did he
statute.
find it? When did he find the statute started running?
What
was his date?
I don't remember the exact date in the record. I do know, though, that
Was there a motion for directed verdict at the end of plaintiff's case in regard to the statute of limitations?
not that I recall, they made it once. It may have been at the end of my case and not at the end of both cases, but they made it once, if they made it clearly at all, because they don't come back to it in their judgment NOV. They don't come back to it at all.
And there was no pretrial motion regarding the statute?
No, there's no written motion on the statute of limitations. They did not argue that. And then interestingly, and I hate to do this, but in 2017, 18, and I can give you the exact case number. Judge Schweikert made a ruling that allowed certain people's complaints to be amended to clearly set out that they were someone that fell within the statute of repose by identifying who was 21, who was 4 years plus 1 versus 1 year plus 1. And I can give you that reference, but I know for a fact that the Weissman case is on that list, as I recall. I just don't recall at this moment if Jones is. And so there was discussion prior to these trials about what facts should be in the complaint relating to statute of limitations issues, and the judge, with the consent of the Dinsmore lawyers, allowed the amendment to the complaints back in 1718. So I don't think the judge abused his discretion, and I don't believe on a de novo review that you're going to find he misapplied the statute of limitations or the statute of repose. He gives his reasons for his decisions, and the fact that apparently they didn't disagree with his ruling because they had the opportunity to revisit it in the judgment NOV, and they chose in both cases to not do it. It's in both cases they didn't revisit that issue. I see my time is up.
Thank you. Ms. Rigby, you have 3 minutes.
Briefly on the statute of limitations issue, Dr. Durrani did raise a statute of limitations defense in his answer to the amended complaint, paragraph 31. Judge Reese did not find a cognizable injury date, and Dr.
Did he just summarily overrule at the end of the plaintiff's, the defendants moved for a directed verdict on the statute of limitations, he just summarily moved, and then it's my understanding from what he just said that you all didn't revisit it in the JNOV.
Dr. Durrani did raise a motion for directed verdict. Judge Reese did summarily deny it. There is no obligation for Dr. Durrani to re-raise the issue in a JNOV. The motion for directed verdict covered the issue.
So he didn't really provide, the trial court didn't provide any sort of rationale or different cognizable event. It just,
No. There was a brief discussion among counsel, but Judge Reese just said overruled. As for moving back to some of the consolidation issues, I would like to repoint this court to the mandamus action. Judge Reese, in his answer, or in the pleadings to the mandamus complaint, said that he deferred to plaintiff's grouping. This court directed Judge Reese to not defer to plaintiff's grouping. That mandamus action was in 2022. Judge Reese did not change the grouping of these plaintiffs or really take any actions that followed that reflected that the trial court followed this court's direction in the mandamus action. These cases went to trial well after the mandamus action. Judge Reese knew that he was supposed to analyze a common question of law or fact, and instead he said the cases were somewhat similar and that the differences helped justify the consolidation. Briefly, just because plaintiffs brought the same claims does not mean that's a common question of law. A common question of law is something like, what is a statute of limitations? Is something constitutional? That's not something that a jury should be deciding. That's common questions of law or something that a court should decide at a hearing ahead of trial. What is most at issue under Rule 42 here is that common question of fact, and plaintiffs don't have enough commonalities, even under this court's rationale in Jones here. If there are no further questions, I will.
thank you.
Thank you. All right, thank you all for your arguments today. The cases are now submitted. Have a good rest of your day.